Thank you, Mr. Chairman. Today's hearing builds on the subcommittee's thorough investigation of the current state of federal rulemaking. Together, we've explored virtually every aspect of the rulemaking process in a comprehensive and, I believe, bipartisan way. We've sought out views and opinions from individuals across the political spectrum in order to identify sensible steps Congress should be able to agree upon to make needed improvements to the regulatory system. Our focus today is independent agencies, which occupy a unique position in our national government. They were deliberately established by Congress to operate independent of the President. Among other things, they are charged with vital public health and safety functions, ensuring economic and financial stability, and serving as students and guardians of fairness and equity on a wide range of public policy issues. These are critical responsibilities, and those responsibilities will certainly require independent agencies to issue regulations when authorized or required by statute. What I want to explore today is how Congress can ensure such rulemaking is of the highest quality. I remain committed to making the nation's regulatory system more transparent, efficient, effective, and certainly accountable. First, Congress cannot lessen its own authority through inaction on critical issues by blurring the lines between legislative, judicial, and executive functions. In some cases, though, excessive delegation to agencies, I think Congress has ceded their responsibility. I don't think there's any doubt about it. The clearest example that I can provide is waters of the United States, where clearly over decades of litigation and decades of rulemaking, there is not a clear answer. One would imagine in that factual situation, Congress would see the important role of stepping in and providing the guidelines that need to be provided, the laws that need to be provided. But yet we don't do it because we'd rather pound the table and complain about regulatory agencies. Simply stated, Congress must pass good laws by taking full responsibility for clearly articulating priorities and goals in legislation. If our statutory directives are unambiguous, we won't see as many claims of agency overreach. Second, while rulemaking is often mandated by statute, we must continue to understand the benefits and costs of regulation. That means that Congress must fulfill its obligation to the American people through oversight of the regulatory process. And this has to include independent agencies whose rules in many cases have more impact on today's business world and today's health and safety world. To be clear, independent agencies face significant challenges in quantifying cost and benefit in the same manner as executive agencies. Nevertheless, in my opinion, their regulatory decisions should be based upon good regulatory analysis. It's not always easy to quantify costs and benefits. Decades of scholarship have revealed that it's often far easier to tabulate costs for a regulation and much harder to capture benefits and quantify benefits. That just means that there will always be a role for quantifying costs and benefits in the regulatory analysis. We should be wary of imposing a one-size-fits-all requirement, which would have serious unintended consequences. We must also be mindful of the regulatory resources if we expect agencies to compete and complete regulations in a timely fashion. Today, I want to hear from our witnesses, all enormously gifted and knowledgeable in this area, on how to improve the regulatory process for independent agencies with a focus on how best to improve congressional oversight. I look forward to continuing my work with Senator Lankford and the rest of my colleagues on these important issues, and I look forward to the testimony today and our continuing dialogue. Thank you, Mr. Chairman. Thanks so much. I mean, we've covered kind of the whole watershed here, from regulatory analysis to where that needs to be done, all the way through judicial review and Chevron. I want to focus on independent agencies because of all of the things that we've worked on, taking Senator Portman Warner's bill, trying to sell it in a political sense, has been a lot tougher than I ever thought it would be, because it seems so common sense to me that if you have a major rule that is being promulgated, no matter who's promulgating it, all the rules should be the same for major rules, and that's not what we have. And so I'm going to offer you some of the criticisms that we've heard from the independent agencies about that concept, and ask you to kind of help me work through, if we're going to do a full frontal attack, right, and say we're going to do this no matter what, and it's going to go to OIRA, then we're going to lose politically. I can tell you that. We've already been I know it's hard to imagine, because when you look at it and you look at the history of this, it's been very bipartisan, but it's been very difficult. And so let's walk through some of the criticism that we've received. First off, OIRA is an agency, a sub-agency of OMB and under the control of the president, and simply giving regulatory review to OIRA under this procedure would in fact interject and interfere with independence. Now, what we've tried to do in response to that is look at another agency, whether it is the IGs, whether it's GAO, take a look at some other place where we could put that kind of regulatory analysis. Because I agree with you, Mr. White. I mean, none of this is ever going to be perfect, but if there's no level of scrutiny or analysis, work can be pretty sloppy, right? You know, your dog ate your homework every day, right? So how do we overcome, or how do we respond to an argument that OIRA is a sub-agency of the president and interference would be, Mr. Gasway?
With the Paperwork Reduction Act precedent, you just say this is for analysis purposes only. There's a carve-out. It's got to go to the expert agency within the federal government on regulatory analysis for their comments.
That makes a lot of sense. However, the bill is very modest in terms of, I mean, it doesn't say they can stop the regulation. Simply says, yeah, it's not binding. There's nothing in this legislation that would give OIRA any authority to stop the regulation. It just would give them review authority. And we still hear the argument that it is overburdensome and attacks the independence.
Well, then I would say this is like sending a medical question to the experts at NIH or something like that for non-binding review. You know, the greatest repository of medical information in our government, I think, is at NIH. And maybe somebody's taking a policy decision and they need medical input. You have to go, you don't have to do what they say, but you have to ask the question. OIRA is a terrific agency with a terrific bipartisan level of competence, and obviously Professor Sunstein is great, but many of his predecessors are. And it is absolutely inconceivable to me, if I were a United States Senator, which I am not, that I would want independent agencies to avail themselves of that expertise. And that's what I would say. Do you really just want them to not avail themselves of that expertise?
I'm looking for an alternative, or because we've said all these things. That's not the problem. The problem isn't that we aren't great at arguing our position. The problem is that we've reached this impasse that we need to somehow get over. And Mr. White, I'm curious, you know, one of I forget which witness talked about the need for coordination. I think it was you. Obviously, OIRA has a much better handle on all of the agency major rulemaking, and probably is the best place to balance what is, you know, what's the Department of Commerce doing against what, you know, the Consumer Finance Protection Bureau might be doing. So it's dangerous to take it out of OIRA, but yet we need to get this kind of review, and we need to change the culture of, I shouldn't say lack of accountability, but kind of this, you know, we have our own funding stream, we have our own, you know, once we get an appointment and confirmation, which is getting tougher to get because of these issues, in my opinion. So now, hands off, we're in charge. And so we're trying to get beyond that. How do we find a mechanism or find a way to do a workaround that would accommodate what we all here believe needs to happen?
Well, if I may, I want to make clear, I don't mean to focus on OIRA to the exclusion of anything else. Okay. Whether it's accountability to the executive branch or to Congress, either through existing mechanisms or some new congressional office of regulatory review, or through the courts. At the end of the day, for me, the most important point is there being a measure of accountability and oversight, not one particular branch doing it. And so I'm open-minded on all these proposals.
One of the concerns that I have about leaving this up to judicial review, and I am not being critical, and maybe I am, but you will hear agency heads saying, we're going to implement this rule. If the court doesn't issue a stay on the rule, then the rule's going to take effect even though the rule was bad. So it's not a process that provides for immediate reaction or some kind of contemporary analysis. And so it fails. Judicial review fails and should be a last resort. That's my position. The chairman and I have had long debates about reform of judicial review, but I'm looking for some way to get this concept over the finish line in a way that we have legitimacy to the argument that we are not imposing presidential review on an independent agency.
If I may just
Yeah.
add, on that point, at the end of the day, like I said, this is about accountability, not just to Congress, but to the people. In the last few years, especially in the aftermath of Dodd-Frank, where independent agencies on financial policy have had ever greater power, you see so many of these regulations, no matter what they say in terms of marketing them as anti-Wall Street, ultimately these regulations benefit the biggest banks and the biggest companies first and foremost, whether it's because of the compliance burdens that the community banks and other small entities face, whether it's through the Financial Stability Oversight Council and others seeming to place a too big to fail stamp on the biggest players. At the end of the day, if an agency is truly independent and not accountable to the people, there's the greater risk that the biggest, most influential corporate players will have a disproportionate voice on policymaking. And whether it's through the president or Congress or through the courts, if the people don't have a real means of accountability for these agencies, at the end of the day, they will have a disproportionately quieter voice relative to the bigger players.
Like your thoughts?
Yes. Well, first, let me just say that from the constitutional structure point of view, if a president wanted to apply OIRA review just to a single agency,
You could.
it could, right? The executive order is the president's prerogative to design however he or she would like. The fact is that there's one piece of legislation that requires agencies to provide statements of costs and benefits of major rules, a piece of legislation that Congress has expressly exempted independent agencies from. So one way of making a cultural change might be for the Congress to say fundamentally, in what we have required of all other agencies, we are going to require of independent agencies as well. That would be a step forward, and it would address something that one reads time and again in responses by general counsel or others at independent agencies on these issues that, oh, we're not required. We have no legal obligation. Amending the Unfunded Mandates Reform Act would, at least for those rules that pass that threshold, would eliminate the ability to make that excuse. So that is one, I think, step that could be taken by the Congress that would also avoid the kinds of political issues that you have talked about, Senator Heitkamp. There are obviously limitations, right? I mean, this isn't maybe providing the optimal level of oversight, peer review, and so forth. But the possibility exists for there to be judicial review, and the ex post threat of judicial review does have some ex ante incentives for agencies up front to do their homework. With respect to homework, I think that the way I would characterize this is, yes, it would be great to get feedback from a teacher, but what is different about Executive Order 12866 is it's not just a grade from the teacher, but also permission to graduate to the next grade. right? So there's this lever, the hammer that hangs over it, and that's causing the kind of constraints and responses that you're talking about, Senator Heitkamp. One other possible approach, it's not mutually exclusive, might be for Congress to impose on, quite frankly, all agencies, something along the lines of the peer review guidelines that OIRA has in place already for various scientific analyses that agencies are conducting. And, this would bolster the Information Quality or Data Quality Act provisions, where agencies could, in real time, get that kind of feedback through a peer review process. Maybe that peer review could come from other agencies, maybe it could come from outside experts, but at least there would be some process of someone reviewing, providing feedback, if indeed the option of having that review by the White House staff is not politically feasible or wise for other reasons.
The luxury that we have on this committee is that we're trying to design a highway. We aren't putting the cars on the highway. We're trying to design a highway that is safe, secure, and accountable for agencies so everybody knows the rules. The problem that we have is we get mired down in analyzing this rule that someone doesn't like or that rule that someone doesn't like, and all of a sudden this turns into a discussion about this agency or that agency, and we haven't had a lot of good luck in saying, imagine that the president is of a different political party than yours. What do you want the rules to be? What do you want the accountability to be? Because this isn't about partisan politics. This is about accountability on how we interact with the American people as the federal government. And it's enormously frustrating to keep, you see this very modest proposal somehow getting painted, even in the New York Times, as a huge giveaway to some big corporate interest that will result in, financial mayhem in 2 weeks if we do it. I mean, and so we're in this highly hyper partisan, exaggerated world, trying to make common sense rules about how we move forward. And no one, if they really sat down like we do on this committee and analyzed the rules or analyzed the growth of what's happening with independent agencies, would ever think that they shouldn't be subject to the same kind of rules or regulations of other executive agencies. I mean, this just doesn't make a lot of common sense. But yet we've created this culture that somehow, as the chairman has said, to have any kind of influence eliminates independence. And everybody loves independence because we all know what that means, independent from politics. Well, there's nothing in this town that's independent from politics. Get in the real world. We have to have rules that prevent overwrought political opinions from basically being embedded in so many of these rules. And so, we need the idea of regulatory reform has become so politicized that the common sense aspects of regulatory reform, whether it's a look back, we're working on a number of retroactive provisions, a number of look back provisions, whether it is, a cost benefit analysis, which has progressed from my days in law school in the 70s, when we first started talking about cost benefit analysis, it was like this magic world. I think it's become much more professional. We have a whole society that's dedicated to improving the quality of cost benefit or benefit cost analysis, however we want to structure that. So we just have not made the factual argument very well, it seems to me, because we keep running into the political argument, we keep running into the hyper argument. And when we can sit down, Mr. White, and you and I nod our heads in total agreement about kind of where we are, recognizing, that we may not agree on everything as a matter of politics, we know that we have some fertile ground here to actually get something done. But we aren't going to get it done if we have the constant sniping at this as this is just a way to shut down this agency or shut down that agency or restrict that agency. We aren't trying to shut down, restrict, or do any of that. What we're trying to do is say, justify to us the decision that you made and the analysis that you did. And we don't want just you, to say, don't worry, I got it. We want there to be someone who is changing the culture we all know that when we have accountability, we perform better. We make better decisions. And so that's the problem that we have, is that this enormously modest proposal was at the heart of really an op-ed in the New York Times before we even got the proposal off the ground. And shame on us that we didn't anticipate that this would be this controversial. It shouldn't be controversial. Because I just keep asking my colleagues, you could have a president that's not a Democrat. What oversight, what accountability do you want for the decisions that are going to be made in that case? And when you can answer that question, then we can get to common ground. But we need people to really help us kind of bridge these gaps and create some momentum without having a package that has become so highly politicized. I think we've got the elements of a pretty good regulatory reform package that would, in fact, amend the APA, would, in fact, do the things that I think 80% of people who live in the common sense world that we live in places like North Dakota would say, well, that should be a no-brainer. We've got 80% of the no-brainer stuff, but we can't get political consensus here to get it done, and it's enormously frustrating. And I think it's because I guess my family taught me that if I'm failing, I should look at what I need to do differently. And so it's not just about these people can't agree with me, it's how do I get this done in the face of this opposition. And so we're really in need of a broader kind of academic consensus out there that these are the 5 things, no matter which side of the political aisle you're on, how you view the world, these are 5 really good reform packages. And I guess that's what we're kind of asking is, how do we build that kind of consensus within a broad spectrum of political thought on what change should look like in terms of regulatory reform. And, I can't leave it without saying this, because I think I say it at every one of these hearings, Congress needs to start doing its job. Right. Congress needs, when we have things that are in litigation for 30 years on definitional provisions of the Clean Water Act, maybe it's time for Congress to actually do its job and provide the lane or the framework for what constitutes things like waters of the United States. And until we figure out how to do our job here, we're going to continue to over-delegate responsibility, I think, to executive and independent agencies. And then it's just a lot more comfortable for us to beat up on the agencies than to turn the finger pointing back at us to say, well, I guess we weren't very clear in what we said. Maybe we ought to change that, because that's a lot of hard work.
If I'm,
so much for my rant.
may I
I'm going to take up an
make a
offering
comment?
after that. So.
May I make a comment? If I could just add to the virtues that have been mentioned for the approach that Senator Portman was discussing, in addition to the modesty of that approach, as you said, Senator Heitkamp. There is another virtue that I think should go noted here, and it does address Chairman Lankford's question earlier about whether it would be appropriate to adopt wholesale Executive Order 12866. And I think that approach would be problematic in some of the institutional aspects or design aspects of 12866. In particular, I'm just not sure how practical the conflict resolution mechanism would work with multi-member commissions if 12866 were to become binding legislation imposed on those commissions. It just as a practical matter, it's hard to see the votes going back and forth. So one of the, I think, the virtues of the approach that Senator Portman was taking, where an OIRA review would lead to an advisory statement that then would need to be responded to, is that there's time for that, and you sort of avoid the practical challenges that would be associated with a back and forth, which is how the executive order is really structured, which is not going to work as well, be much more cumbersome with the multi-member commissions. And commissions, by the way, that are headed by individuals who, in many cases, cannot be removed at will by the president.
You know, just one more observation, and I think when you get down to it, this is not an exact science. And if people want to kind of say, you missed the boat. But the other piece of this that's so critical, and it goes back to the other pieces we're trying to pull together, is the retrospective review. And so we have a bill that received unanimous approval in the committee that would require every new major rule have a provision in it that was noticed that would require retrospective review within the provisions of that new rule. We have to deal with the body of work that's out there, but if we don't have retrospective review, we don't learn about the mistakes that we made in the last cost-benefit analysis, and so we don't improve the quality of that work overall, because there's never a look back or a judgment. And so these are, we keep trying to compartmentalize these, but the package itself is what's going to get us where we need to be. And we laugh because the one area where we probably have some of the most interesting discussions between the chairman and the ranking member is Chevron. So just to give you a little insight.